Time now for a debate on Proposition 137, a ballot measure that would eliminate most judicial retention elections for state Supreme Court justices and Superior Court justices in Arizona's larger counties. Proponents of Prop 137 say that retention elections are a way of separating judges from partisan politics. Opponents argue that judicial retention has worked for years and there's no reason now to get rid of it. Joining us now in support of the measure, State Representative Alexander Culloden, and in opposition of Prop 137, Cathy Sigmon, co-founder of Civics Engagement Beyond Voting. Good to have you both here. Thank you so much for joining us. We'll start with the proponents. We'll start with why you think this is a good idea for Arizona.
Well, it's just like you said, Ted. We have to get politics out of our judiciary. You know, judges are not politicians. In fact, they can't even campaign on their own behalf. So what happens with these judges? Well, dark money groups launch campaigns for and against them. Now, I don't know about you, but I don't really want my judge, if I have a case in front of him that's significant to my life, thinking about, well, how is the decision I make going to impact whether money is spent for or against me in my election? What I'd much rather have is a judge who sticks to the facts and to the law. And these initiatives, these retention measures, they are confusing to people. There's almost 50 judicial retention elections on your ballot. That's way too many to research. What we propose to do is give voters a smaller and more curated list of judges that you're actually going to have time to do your background on and cast an informed vote.
What's wrong with that idea?
Well, Prop 137 is actually a partisan political move to wrap our current judiciary in bubble wrap and freeze it against the transparency and accountability to the people. Not only that, but it would throw out our votes in the November election, so it would completely cancel our votes, and it would make sure that we do not have any accountability over the judges in the future. Actually, my Representative Culloden here introduced an amendment that brought partisanship directly into the judicial performance review process by requiring that two partisan legislators sit on the performance review commission, and also allowing any legislator at any time to bring a complaint about a judge that they don't like.
You want to respond to that?
Absolutely. So the amendment that I offered and was accepted is a way of preserving checks and balances. You know, in our federal Constitution, there's an advise and consent process where the president appoints and the Senate confirms. And so whenever you're adjusting the way the checks and balances are working, you've got to make sure that you're going to substitute something for it. And what we did is look at the federal model and decide to adjust it in a way that closely matched the federal model. And I don't know, what she's saying about a partisan legislator being required. In fact, the amendment allows the legislature to appoint whoever they want to the Judicial Commission. So if there's somebody who's a respected jurist, somebody who's a respected professor, they can be appointed as well.
We already know what an unaccountable judiciary looks like because we have the federal model. We have the U.S. Supreme Court. The Supreme Court has been embroiled in concerns about their ethical responsibility, their yacht vacations, their loan forgiveness, and ditching decades of precedent. If that isn't political, I don't know what is.
But in terms of accountability, is there not a difference between judicial accountability and political accountability? And should judges, should they fear political repercussions on a decision that they think might go against the tide?
I would present that judges are highly political. And by political, I don't mean necessarily partisan. They make they make decisions about so many things in our daily lives. Plus, they don't just read the law, they interpret the law. I don't know about you, but my reading of laws is not necessarily clear and precise, and so the judges have to read into those laws. If the laws were straightforward, every judicial decision would be unanimous. And even in the decision that returned Arizonans to the 1864 abortion ban, there were two very passionate dissents.
Okay, but again, in terms of accountability, if this goes away, how are these judges held accountable by those that they are judging over?
Well, that was what the amendment was about, is making sure that that accountability mechanism stayed in place. There is a body called the Judicial Performance Commission. And that Judicial Performance Commission gets surveys from people who actually appear in front of the judges and the attorneys and figures out, did this judge act in an ethical fashion? Were they fair to all concerned? Did they hear everybody out? And then they make an evaluation before every election cycle. Did this judge meet judicial performance standards or not? Well, if they decide that they did not, that judge still goes on the ballot. But here you have professionals making that first cut evaluation so your ballot doesn't get flooded with 50 judges. That the only judges you're going to see on there are the judges for whom that this professional body says, this person may not be up to snuff.
Yeah, and the commission right now, we have the commission chair on the show. We've done programs on this throughout the years. They basically give their recommendations and they say, here's what they are, here's a recommendation for you. They don't make a recommendation that would keep others off the ballot. Is that too much to give to the commission?
I don't think so, because of that amendment. Again, because the legislature now gets to put one person. By the way, there are 30 plus people on this commission. The legislature is now going to get to add one person per chamber to ensure that the commission is accountable, does its job, make sure that judges who really don't meet standards do wind up on the ballot. But what we're not going to do is overwhelm voters. I mean, I'm a practicing lawyer, and I got to tell you, I'm looking at the judges on my ballot saying, I can't cast an informed vote on this many different judges. I don't know half of these guys. If I had 5 to look at, I could actually do my research and make an informed vote.
Should the commission be able to winnow down that list so that only those that may or may not meet the standards that the commission heard? Obviously, everyone in the judicial community supplies information to the commission. Why not winnow it down, narrow it down, make it a little easier?
Well, first, I would like to say that one of the arguments that politicians have made in favor of Prop 137 is that we voters should not have to worry our little heads about all these judges. And I really find that laughable. This is a system that has been working very well for almost 50 years. It was created by Citizens Initiative. The people wanted this, and supported by Justice Sandra Day O'Connor back in 1974. So I really don't see any reason to change our current performance review system.
Good enough for Sandra Day O'Connor, good enough for the past 50 some odd years. Why not good enough now? What happened? What changed?
I don't think it was ever good enough. I think that was always a work in progress. This idea of merit selection was a new idea. It came about in the past several decades, and we implemented it this state. And now it's time for us to tweak it.
Okay, is it time to tweak it because 2 Supreme Court justices who agreed that the 1864 abortion ban in Arizona should be the law of the land, they are up for retention in A, and B, the retroactive nature of this measure? I mean, how much is that decision and those 2 justices a part of this measure?
So the funny thing about that is I happen to know one of those judges. And the way he decided that case was very much to the contrary of his own personal viewpoint. But that's what judges do. They're not policymakers. So he, as a good, honorable judge, was bound by what the law actually is. And the other side of that case basically based the entire case on this idea that Nancy Bartow, who I believe your organization called pro-forced birth, somehow sponsored a law that would have legalized abortion up till birth to 15 weeks. It was an absurd argument. It would have made a mockery of the law for the court to accept it. And then guess what? They turned around and let the AAA initiative, the Arizonans for Abortion Access initiative, on the ballot. These are decisions that are explained by people who are not substituting their policy preferences for the will of the voters.
The 1864, again, the abortion ban, how much is at play here? And again, these are justices who, we would think, made decisions that they thought were correct. How much should they pay a penalty for that judicial decision?
Judges bring their ideology onto the bench, their ideologies. Ideally, they will set those ideologies aside when they make their judicial decisions. But as I said, they do interpret the laws according to their experiences, their studies, and their perspective. For example, Justice Bill Montgomery, who was notorious for politicizing the Maricopa County Attorney's Office, particularly expressing his extreme dislike of LGBTQ Arizonans and abortion, he did bring those ideologies onto the bench. And if those find their way into judicial decisions, that is poisonous. Arizona voters have every right to judge the judges based on their political bias.
Should Arizona residents lose that particular right?
Well, they wouldn't lose it under this. But the other thing I would say is...
Well, they would lose it under everyone on the list. That big, long list that you talked about, that list won't exist. That doesn't exist anymore if this passes.
What I believe my opponent is suggesting is that judges be treated like politicians, that a voter looks at those judges' decisions and says, do I agree with that as a matter of policy? But that's not how judges make decisions, and it's not how judges are supposed to make decisions. Judges are supposed to stick to the law and the facts, regardless of what their own personal opinion of what the law should be is. If you're mad about what the law is, vote me and my colleagues out of office. But don't vote judges out of office who are just doing what the law says they need to do.
Respond, please.
Well, it seems to me that the partisan Arizona state legislature does not trust voters to have the common sense to make informed decisions about the questions on their ballot. I don't have to be a lawyer to say that I think it's wrong for them to take our votes from the November election and cancel them, and also suppress our ability to have judges face public accountability in the future.
I want to make a point here.
Please, quickly.
Yeah. A lot of people on my side are mad at the Supreme Court judges, too. We don't feel like we got a fair shake in the election stuff, okay? But we cannot let the way that a judge applies the law, which we may not like, right? We cannot let that influence the way that we vote. We have to allow judges to be fearless and go wherever the law and facts take them. That's what this measure allows, while still giving voters a mechanism to remove underperforming judges.
I gave you the first shot, you get the last shot.
Well, I would say that judges do almost always go where the law takes them. However, there are certainly cases where they bring their ideology onto the bench, and Arizona voters have every right to weigh in on those decisions.
All right, we have to stop it right there. Good discussion. Good to have you both here. Thank you so much for joining us.
Thank you.